Hello viewers, I'm Melanie from Kongwe, a law student at the Vegetable School of Law, undergrad Zimbabwe University. In the area of contract law, Mr. Maposa is my lecturer, and today I'm going to take you through option in contract law. So basically, under this topic, we are supposed to know what a contract is, how it works, when and where it works. Um, Under this topic, we are also going to notice that options are basically or are usually used for securities, commodities, and real estate. We may as well find out that options they are part of our daily lives, our everyday lives. We contract each and every day, but without the legal implications or the legal knowledge, one may not know about the consequences of the implications that may arise. So, starting mainly with the definitions, I've found two possible definitions, maybe three, that are simple to understand. So, an option is a type of contract in its own right, and it seeks to make an offer irrevocable for a certain period of time. The following definitions can help us to understand better. The first definition of an option is an option can be defined as a contract to keep an offer, which is the main or substantive offer, open usually for a certain period of time. The main offer, we are saying the main offer is irrevocable or cannot lapse for a certain period or duration that is stipulated by the offeror and the offerer. It can also be defined as an agreement between a buyer and a seller that gives the buyer the right to sell a particular asset at a later date, which is the expiration date, and an agreed upon price, or simply an agreement not to withdraw an offer. So let us look at other examples of options, basic examples or general examples of options. Number one, we have A, who offers a car to B for sale at a price of $13,000. B wants to buy the car, but is not sure if she can raise the money to do so. So what B does is to consider the offer, but delay on her part entails the risk that A might sell that car to a third party. So in this case, B asked A to give her 3 days to raise the money, during which A cannot withdraw the offer, and this means that B has an option to buy the car. Another example is we are saying a person can rent a space at a particular shopping mall, and then there's a lease period which is stipulated that it is for 5 years, and within an option to renew the lease for a further period of 3 years. And for further and clearer examples, we can check the book, The Law of Contract in South Africa by Hutchison et al. On page 87. It is often stated that for every act there is a consequence. In this case of options, the consequence lies on the requisites of the option. This means that the option contract must satisfy all the requirements for a valid contract. More so, in terms of the main contract, um, an offer in terms of the main contract must satisfy all the requirements for a valid offer. In a nutshell, we are saying that for an option to be valid, it must satisfy all the necessary requirements, namely agreement. That's the number one requirement. Where we are saying, being a contract in its own right, the option must reflect consensus between the offeror and the offeree, or the parties that are going to be in agreement. And if the main offer is invalid, then the option contract will fall for lack of certainty. We are now moving on to see the juristic nature or the legal nature of a contract, an option rather. From the previous explanations, it has been established that an option comprises of an offer to enter into the main or substantive agreement and the agreement to keep the offer open for a certain stipulated time. An option contract in its own right. An option is a contract in its own right. Thus, it must satisfy requirement for a valid contract, including the one for consensus. For instance, A offers to sell a car to B and says that she will keep the offer open till Monday next week. We must note that the offer to sell the car is the main offer or the substantive offer. Number one, if B immediately accepts or rejects the main offer, the offer of the option will fall away. Number two, if B says he's going to think about it, then he has accepted the offer of the option, but not the main offer. And we are also saying that if before Monday B accepts the main offer, he has exercised this option and concluded the main agreement of the sale. And lastly, if B does not respond to A's offer, then the option is going to lapse and the main offer also falls away. Now, from the given examples, ladies and gentlemen, it is clear that an option creates rights and duties or obligations for the parties. The grantor of the option has the obligation not to withdraw from the offer for the stipulated period and also not to do anything that frustrates the grantee from exercising the option. In this case, the grantee who's being granted the offer option, has no corresponding obligation. If the option is granted gratuitously, but if the option is granted for a fee, then he or she has to pay the fine. Those are the obligations or the rights that are created within an option contract. It should be noted that the fact that an option is a contract on its own has not been fully appreciated by the courts. In the case of Van Plassen versus Henning, Solomon J. stated that when an option is given by a seller, he is bound and cannot withdraw the offer. This means that the contract will be unilateral and only becomes bilateral when it is accepted. However, in the case of Hess versus Neil, the judge used a different approach by implying that an option must simply be seen as an agreement between the two parties, the giver and the holder of the option, by which the giver is bound himself to sell a certain thing to the holder at a certain price, if he shall require him to do so at a certain time fixed by the option. Thus, the giver grants and the holder acquires a right to buy. We move on to the next question, which is often asked, whether or not an offer is irrevocable. In other words, we are saying, does granting an option render an offer irrevocable? To answer this, in practice, offers are frequently declared irrevocable, and offerees rarely notify their acceptance of this offer of irrevocability. Hence, to treat silence as tacit agreements brings about legal friction. Let us look at the case of Boyd and Neil. The plaintiff had been given an option to buy land by the defendant, who put it out of his power to carry out the terms of the option. Before the expiry date, the plaintiff sued for damages. The trial court held that the option was merely an irrevocable offer and that until the offer was accepted, no contract arose from the breach in which the damages could be sustained. This means that the plaintiff had the full period of consideration whether to buy or not, thus the defendant was entitled to abide by the agreement. In other case, we are saying that one cannot revoke an option contract before there is agreement. Let us also look at the duration of an option. An option given for a fixed period may not be withdrawn by the grantor, and the offer is open for acceptance or rejection by the option holder at any time during the fixed period, but may not be accepted after the fixed period has lapsed, unless it can be shown that the grantor has waived the limitation of time. In the case of Smayman versus Volkets, V orally granted S an option to buy his shareholding. The option was supposed to be exercised on the 15th of February. On the day, S's attorney was asked to exercise the option on behalf of S. Thus, he phoned V's office, but he was away. Therefore, He then posted a letter saying S had chosen the option and wanted to exercise it. This letter was delivered after the 15th. Then the court held that no contract had come into existence because the offer contained in the option had not been accepted timeously. So it is therefore important for the offeror and the offeree to effectively communicate on the exact or specific period of lapse of the option, offer, or contract. After this, we are also looking at whether an option rights can be transferred. Basically, the general rule is that unless stated otherwise, personal rights may be freely transferred to a third party by cessation, which means to give up or to silence. We must also note that there are certain formalities required when creating the option contract. The formality or formalities are taken note of, especially in the sale of land. In the case of Brand versus Spice, S granted B an option to buy a farm orally. S later repudiated the option and was sued by B for damages on ground of breach of contract. The court held that no contract existed since the sale of land had not been in writing. For a contract to be in writing, the offer and acceptance must also be in writing. This means that no written offer had existed for B to accept the sale of land by S, thus there was no contract. On the other hand, also with the case of Gishowitz versus Mooman 1985, where the appellate division stated unequivocally that a pactum de contrahendo is required to comply with the requisites for validity, including requirements as to form applicable to the second or main contract to which the parties have bound themselves. We can also look at the issue of breach of options or breach of contracts and what happens after those breach suffice. The consequences of a breach of an option are determined by applying principles of contract that modulate breach and solutions for breach, because we are basically saying that an option is a contract in its own right. So we use those general principles for a breach of contract to regulate or modulate what a breach which has risen in an option contract. If the breach is a material one, the innocent party has an election either to cancel or uphold the contract. If she elects to cancel the contract is terminated and the innocent party is entitled to reinstate or reinstitute any performance that she has under the contract. If the latter also decides to uphold the contract, she is entitled to an order of specific performance by the court, compelling the party in breach to compensate the damage if financial loss resulted from the breach. So there's an issue of compensation when one breaches an option contract. There's a diagram which explains further. So that was it on option. Thank you very much for watching.